Yep.
What was that?
Yeah, like that.
He voids the Jew before approval.
So, folks, ladies and gentlemen, does everybody understand what was about to happen in March of 1801? Yes.
John Adams.
But before Adams did that, what was going to happen on the March 3rd date? That?
Congress, whatever Jefferson. He's a Republican.
Okay, and the president. So the Federalists are freaking out. At this point, back to what Danny said, there was a law that was going to create a bunch of new judges. Basically, we simply decided we had too many scummy. We needed more judges, we needed more courts, and that's where the problem. The issue was John Adams, basically kind of like a really bratty kid. He was president for another, whatever it was, 6-7 hours, and he sat there and began to fill in paperwork. The question is, as underhanded as this may have been, Jefferson appointed Federalist judges. Jefferson is angry. I said that wrong. Adams appoints Federalist judges. Bless you. Jefferson decides that this was a violation of democracy, what the people wanted, and he throws them out. Is there any questions at this point?
Yeah, how is that like not illegal?
What?
How is that not illegal?
Which part?
Like him throwing them all out.
And that's where we're headed. Folks, at this point, do you know how, the sad thing, folks, is a lot of times people have their rights broken. A lot of times they're not done properly, and sometimes the police or the government gets away with it unless someone raises questions. What's the best example of that? So, what was the law that overwhelmingly was a slap to the face of every single American that will be on the test on Wednesday? Specifically, which one? The Sedition Act says you can't even criticize our government, right? The First Amendment literally was ignored. Unless people voiced their opinion, protest, higher, the act was the law of America. Do you guys understand that in 1867, oh, technically it wouldn't be true. By 1870, every single state in America had African Americans the right to vote. You guys all know that? In 1870. So basically, that means, right, that every single African American was allowed to freely vote from 1870 through the next 100 years? Martin Luther King Jr. was just an angry, disgruntled guy who made up something? In 1870, we passed amendments that said African Americans could vote. And for 90 years, we ignored laws that we made. To some degree. We found ways to get around them, Jim Crow laws.
That's what I was going to say.
So here we go. Ladies and gentlemen, and this is the question Eli asked. At this point, it's not that big of a deal. You have a situation where Adams did one thing, Jefferson another. There's people who are angry on both sides. The question really is, did someone do something wrong? Did Adams do something wrong? Did Jefferson do something wrong? And the only way to figure that out is you would have to basically get some ruling or decision. That brings us to William Marbury. There is no doubt, folks, you will need to know William Marbury's name. In my opinion, William Marbury is a lot like Rosa Parks. Rosa Parks is a young woman who wanted to do what? Sit on a bus and not give up her seat to a white man. William Marbury was one of the Federalist judges who had his judgeship destroyed. William Marbury believes he was cheated. How does he relate to Rosa Parks? William Marbury begins to put up a stink, begins to start arguing, and eventually he hires a lawyer and he begins to argue this was wrong. So William Marbury is going to sue that what Thomas Jefferson did was a violation of his rights. That Thomas Jefferson broke the law. Now, some of you may notice the court case says Marbury versus Madison, and the reason? The United States Constitution makes it almost impossible to sue the president for non-criminal acts. for basically his job. Why do they sue Madison? Because under the law, once a document or paper, the original judgeship was signed, the Secretary of State was the one who was in charge of the distribution of it. So the reason Madison's name is on the thing is the argument was he was the one who was supposed to protect the original judgeships. When he could do that, he is the one who basically violated the law versus Jefferson, who technically did it. Because the argument is Jefferson simply, appointed new people. Just so you understand.
So, wait, did Jefferson really have time for new people, though? I mean, because he was just beginning.
Remember, Adams did his in 6 hours, right? So here's the situation. Folks, as we've already mentioned, and some of you know, the biggest problem with what Marbury wants to do is courts can blow. Because you start with a district court, you go to a circuit court, and eventually go to appellate. And imagine that each court takes 2 years. By the time you make a decision, that would be roughly 6 years from now. I mean, the whole point of this is the Federalists are trying to not lose control of the court.
Why didn't Jefferson just hold on to them until, like, Congress and all that had changed?
Because part of it was that the Senate was, still had enough sway in the Senate that they probably would have passed them. There was also wood senators at this time in history. At this point, you notice, Pete, generally the Congress is bless you, is going to side with the president. It'll take time. Congress begins to challenge. So here we go. This is what happens, and this is where all the Marbury and a group of his friends find this little itty-bitty clause. Remember the law that created the district courts, created the circuit courts, mentioned judicial review. In the Judiciary Act of 1789, there was a clause that says government employees, if there is a job dispute, so for example, there was a discrepancy over your job description, there was a clause in the Judiciary Act of 1789 that said a government worker could appeal directly to the Supreme Court, and those of you who are trying to figure out what's the big deal, the Supreme Court is what? A court of last resort. When the Supreme Court rules, it's final. There's no appeal. The Federalists could skip right to the, it's kind of like, going directly to go. What is the ultimate, the other big benefit? Up until this moment, this is, the only presidents have been what kind of people? Federalists. Judges are appointed by the president. Ladies and gentlemen, a logical person would therefore deduce primarily made up of Federalists. Ladies and gentlemen, what I want you to notice is everybody is looking at this as a bipartisan party issue. Jefferson and his cronies believe that what they did is fine. Adams and his cronies believe what they did is fine. What everybody believes is if you can get to people of your party, they will side with you. The Federalists believe the Supreme Court would be to their side because they will side with Adams. The Supreme Court agrees to the case. Don't get too flipped out. What is called a writ of mandamus simply means the Supreme Court says we will look at, we will examine. So in 1803, the United States Supreme Court orders Marbury v. Madison to come up to them. At this moment, please write down the name John Marshall. John Marshall will become the first significant, important Chief Justice that you need to know. In fact, from the year 1800 to the year 1835, so for 35 years, it will be known as the Marshall Court. John Marshall, 1835. Folks, this is it. This is the case trumps all other cases. Raise your hand and tell me what appears to be the two options.
Say that Jefferson was either right in what he did and Adams was wrong, basically, or side with Marbury.
Ladies and gentlemen, either Marbury gets his job or Marbury doesn't. In the grand scheme of the United States, how many people would this actually affect? One. Ladies and gentlemen, that is the problem with the Supreme Court. The Supreme Court, and that's why John Jay said it was a rubber stamp, literally, this was a case-by-case basis. Even if they say that Marbury gets his job, those other judges would then all have to file suit And at most, you deal with what? 18, 20 judgeships. It has no effect on everybody else in America. The Supreme Court was weak. So look at the options. If you give him the job, the Federalists are going to be happy and Jefferson will be pissed. If you don't give him the job, the Federalists are going to be mad and the president proves he can do whatever he wants. You might want to put a little warning sign, maybe a little asterisk. If the Supreme Court rules that Marbury gets the job, who are they basically going against? The President of the United States. In 1803, who has far more prestige and importance? The President. Is there any chance in the year 1803 the United States House of Representatives will charge Thomas Jefferson with impeachment? None. My question is, John Marshall and the Supreme Court also have to deal with the issue. What if the Supreme Court rules Marbury should get his job back, and what if Thomas Jefferson comes out and publicly says the court is wrong? Jefferson says the court is making an error, the court is wrong. Could the Supreme Court in 1803 win a fight against the president? For those of you shaking your head, no, yeah, but maybe. Is it a battle the Supreme Court could win? Because if the Supreme Court loses flat out, what is going to be the absolute importance, prestige of the Supreme Court? None. Ladies and gentlemen, this is the most difficult thing for you to understand. John Marshall is not thinking about William Marbury. John Marshall is thinking about the Constitution. John Marshall is thinking about separation of powers and checks and balances. And flat out, at this moment in 1803, the United States Supreme Court is toothless. It has no ability to defend itself. With that in mind, John Marshall in the United States Supreme Court picks door number 3. Did everybody hear me? Folks, this is the big item. The United States Supreme Court announces they are not going to give him the job. They're not going to not give him the job. The United States Supreme Court announces we will use judicial review and void the original jurisdiction clause in the Judiciary Act of 1789. Now, for those of you who just got lost, remember the reason all this is there was a law, a clause in the Judiciary Act that allowed Marbury to skip right to the Supreme Court. In the Constitution, it only grants original jurisdiction in the case of treason. Was anyone being charged with treason? No. The Congress gave the Supreme Court power that is not in the Constitution. What the Supreme Court is saying is the Congress cannot violate the Constitution. By doing this, Marbury, they're saying if he was right or wrong. The Supreme Court is literally saying we don't have the authority. The case would be thrown back to the lower courts. Ladies and gentlemen, for those of you who are lost, this is not about Marbury. It never will be. Voiding the Judiciary Act of 1789 is what? What is that? Ladies and gentlemen, in Marbury v. Madison, the United States Supreme Court, remember in the Federalist Papers, remember in the Judiciary Act of 1789, we have hinted at judicial review. Judicial review is the ability of the Supreme Court to look at a law, an action or policy, and determine if it supports or violates the Constitution.
Did you say it would get thrown back to them?
Yes.
I thought the Supreme Court was final.
What they are throwing out is the original jurisdiction clause. They make no ruling on Marbury. The Supreme Court is basically saying we are going to rule on the law that allowed him to leapfrog. That law was wrong. We'll come to that.
How did Congress violate the Constitution?
The Constitution specifically says the Supreme Court is an appellate court with the exception of treason. The Congress then gave the Supreme Court an additional original jurisdiction. The Congress gave the Supreme Court power that was not implied in the Constitution. Now, folks, yes.
It seems kind of like a conflict of issues.
Oh, hugely.
Because, like, if we're talking about judges that should have been in place of the judges that are there right now, right?
They weren't Supreme Court judges, though.
Oh, they weren't. Okay.
The judges who were in place would have been circuit judges,
Okay.
like appellate judge, the lower appellate.
Okay, sorry, I thought.
Here, but there's a better one. Folks, when you look at Marbury versus Madison, there are two radically different ways to look at it. The absolute single most important thing is what in the heck just happened. Gentlemen, as I look around the room and Oscar's about to fall asleep, this will come up on multiple units this year. I guarantee Mrs. Randall is going to teach it. Marbury versus Madison is the benchmark because without it, there are no other Supreme Court cases. Marbury versus Madison is the court case that creates all the rest. Without judicial review, the Supreme Court is absolutely worthless. What's the problem with the creation of judicial review? Didn't ask. The Supreme Court argued original jurisdiction is void because it's not in the Constitution. But in order to do that, power that is also not in the Constitution. So, ladies and gentlemen, here's the question. Is Thomas Jefferson taking a loose interpretation by letting the Supreme Court use original jurisdiction, or excuse me, letting the Supreme Court use judicial review, or is Thomas having the Supreme Court void the original jurisdiction? Ladies and gentlemen, that's what politics and lawyers do. There are two ways to look at it. Right now, it is not about the night of midnight junction. It's a cute story. It's very political and angry. Versus Madison matters because of judicial review. The Supreme Court has done it. They are going to do it again. What's the big controversy? When they announced it, using a strict interpretation, would Jefferson object and say, you can't do that? You don't have that authority. And let's be honest. Does everybody see the trap? If Thomas Jefferson says, Supreme Court, you can't do that, you don't have judicial review, Jefferson would therefore be telling the court they must make a decision. The United States is telling the Supreme Court, you must make a decision. What is it going to be very hard for the presidents to not accept? What decision would the Supreme Court probably make? Jefferson was wrong. Marbury gets his judgeship back. Those of you who your brains are clicking through, it's a trap. Either we get judicial review or Marbury will get his job. Jefferson has to decide between the lesser of poisons. One, do I give the Supreme Court a power they need, which is, by definition, a loose interpretation because judicial review is not in the Constitution? Or do I tell the Supreme Court they must make a decision? The Supreme Court probably will side with Marbury, and then Jefferson's going to look out to be a cheater, a person who violated the law.
Could judicial review fit under necessary and proper, or is that only for Congress?
The problem is the necessary and proper is specifically Congress. So it would be a bigger stretch. Does everybody understand how if I'm Thomas Jefferson, I'm going to argue that it was a strict interpretation? The original jurisdiction clause was the violation, right? Folks, what am I trying to tell you? When we started with Jefferson, the big hint I gave you is people often ask, does Jefferson loose or strict? No matter how you want to argue it, the Supreme Court under Jefferson just got what? Which is the ability to review the Constitution. Judicial review is not little, it is huge. It is ginormous. When we look at the checks and balances, that is the thunder of the Supreme Court. Without judicial review, the Supreme Court literally deals with people on a case-by-case basis. By throwing out the Judiciary Act of 1789, who was it thrown out for? You guys are missing it. When the Supreme Court uses judicial review, was it just for Marbury? Was it just for this case? It's thrown out for what? Everybody. So later in history, when the United States Supreme Court makes rulings on things like slavery, will the issue just be for the people in the case or for everybody in the country? Please understand, review, this was kind of the debate in the Kentucky and Virginia resolution. Judicial review makes the Supreme Court guardians of the Constitution. Remember the whole Sedition Act? If the Supreme Court had judicial review, they could have examined the Sedition Act and said it violated the Bill of Rights. You can use this whichever way you want. If you argue strict, you say Jefferson was basically saying that Congress was out of control, the original jurisdiction. If you're saying Jefferson is loose, you would say that he allowed the Supreme Court to create the original jurisdiction. And folks, it's not an issue of was it a good power or bad power. In a strict interpretation, what does it mean?
Word for word.
Is judicial review in the Constitution? What is the only way to put something in the Constitution? Did Jefferson make an amendment? Therefore, by definition, it is a loose interpretation. Is everybody okay? Folks, you may disagree with me, but I think what makes sense now, and these are going to take place over the unit, we are going to go over a series of court cases. So what we are going to do now is we are going to find out how Marbury versus Madison is going to affect other issues. And the first one is Fletcher versus Peck. Fletcher versus Peck. Year is 1810, so this is still under Jefferson. Well, someone's going to catch me. 1810 is the Supreme Court. That would be Madison. The actual case, the incident took place, I believe it was in 1807. So please be aware the incident of the case deals with what is called the Yazoo land deal. The Yazoo. And I used to have a student named Matthew, and he used to every time sit and go, Yazoo! And it made me... Anybody remember who was the original Georgia guy? Anybody? Oglethorpe. Remember the 50 acres, and that fell apart? And does anybody know by 1798 what was the new product sweeping America? Cotton. And ladies and gentlemen, the land of Georgia was all of a sudden becoming exceedingly valuable. So what was happening? The poor people going there? Who's buying up Georgia? Rich people. Ladies and gentlemen, there's an enormous piece of land in Georgia called the Yazoo land. And the state of Georgia decides to sell it, and here's where the controversy comes. The state of Georgia decides, instead of going into the business of surveying and dividing the land, the state of Georgia sold all of the land in one big lump, and this was like hundreds of thousands of acres. They sold it to 4 real estate companies. And the idea was the real estate companies would then go about surveying, dividing, and then opening the land up for sale. Okay? And please understand, folks, when we say that they bought up the land, Georgia has a lot of swamps. Georgia has a lot of land that is not very desirable. The land companies bought everything. That way, the state of Georgia got a big lump of money, and they could take that money to deal with other issues in Georgia. The land companies then begin to survey the land, they begin to divide it, and then of course rich people start buying up Georgia.
Is Louisiana purchasing it?
Coming. Here's the controversy. Some of you know people like this. The deal goes through, Georgia sells the Yazoo land, the land companies begin to start surveying the land, they start putting up their survey stakes, maybe some people start buying segments, and of course somebody goes, wait, when did that go up for sale? How did that happen? I didn't know about this. How come I didn't get a chance to buy it? And of course, what is the number one thing that hits the newspapers? If you divide the purchase price by the land, it's like less than a penny an acre. People freak out. Because grade A farmland in Georgia was selling for $3 an acre. Clearly, what's the argument? They bought a huge amount of land that nobody could probably afford by themselves. And 2, they bought the good land and the bad land, and if you divide it together, that was the average price. Ladies and gentlemen, of course, what does the average person see? The state sold land for a penny an acre. And of course, what do people demand? This isn't fair. This is, remember, here in Wisconsin, remember the big recall of Governor Walker? In Georgia, the people of Georgia went on a massive recall. The people were angry. They felt that this was crooked politics. They felt the politicians were like rewarding their friends. And there was this massive recall. They went out and they elect new officials. And ladies and gentlemen, here's the big item. This is, seriously, the new Georgia legislature announces they are going to void the Yazoo land sale bill. They are going to void it. It was a bad bill. That was stupid. They're going to void it. They're going to give the land companies their money back, and they're going to resell the land. Does anybody see a problem here? Yeah.
What about the people who already bought the land?
Okay. But does anybody see a bigger problem?
The land is worth more money than they paid for it, so obviously they're gonna want more money.
You guys are missing the problem. Folks, each and every one of you on a regular basis, you buy things. What does this court case open up? What? What right? What happened here though?
If they had the right to sell it or not.
Okay. But what's the problem?
The government took the land company's property.
Okay. Ladies and gentlemen, let me give you a story. True story. About 15 years ago now, a guy was at a auction, flea market, Ivana's clearing out her attic. The guy went to the flea market. He finds this god-awful picture frame. It's got this like wallpaper design. It's hideous, but the frame looked really old. And the guy offers $65. The gentleman takes the frame home. He wanted the frame. He pops it open to get the gosh-awful picture out. He pulls off the gosh-awful ugly picture, and behind it was one of the original, 17 copies of the Declaration of Independence. Not a fake, an original.
No, he just wanted the frame.
Ladies and gentlemen, does the woman have the right to say, wait, I didn't want, I want my picture, I want my picture frame back? Why? She got a bad deal? Well, wait a second. The state of Georgia, they made a bad deal and they got out of it, right?
That she claimed she was only selling the picture and the frame.
No, ladies and gentlemen, the question is, if you make a contract, can people void the contract? Is what the state of Georgia did illegal? That's the question. Ladies and gentlemen, it goes to the Supreme Court in the case of Georgia Pack, and flat out, Thomas Jefferson supported the state. This is a great example of Jefferson supporting state rights. Jefferson believed, like Whiskey Rebellion, Jefferson believed there was a mistake, we fixed the mistake, and Jefferson believes that as long as justice was done in the end, it's okay. The problem is think of what was said before. I think Aria said it. Remember how the land company bought the land, then they sold it to other companies. The problem was we had a contract, and then all of a sudden a few years later, people said, well, it wasn't fair. Well, if that's the case, folks, every time you buy something, how do you know that someone isn't going to come and say, well, that was too good of a deal? Right? So we go to the Supreme Court. The issue is, does Georgia have the right to fix the Yazoo land sale? Can they void a contract? Fletcher versus Peck, 1810. Folks, And you know the crazy thing? This court case deals with each and every one of you in this room at this moment. The United States Supreme Court rules what Georgia did was wrong. What the Supreme Court rules is the land companies did nothing illegal. The land companies did not violate the law. The state of Georgia made a deal. Ladies and gentlemen, when you make a deal, there is no promise you get a good deal. There is no promise that you should not have, thought longer. There is no promise that the market won't go further up or down. You made a deal. Ladies and gentlemen, this is called sanctity of a contract. The United States Supreme Court rules that what Georgia did violated the rights of the land company, because the only way we can void a contract in this company, remember the lady who bought the Declaration of Independence? Both people would have to agree to void the contract, not one. When you walk out of Walmart, folks, they can't come running you in a parking lot and say, hey, that item wasn't supposed to be on sale. It's too late. Once they take the money and give you a receipt, it's yours. Do you know where the funny part and the opposite? If they charge you the wrong price, most stores will fix it. But really, that's partly your responsibility. Really, you should be paying attention when you go through it. Now, if the prices were marked wrong and stuff, then that's their fault. But if the price rang up what it was supposed to, it's not. One other thing you need to understand, folks, Fletcher versus Peck is sanctity of a contract. I cannot tell you how important that is. Folks, otherwise, if it wasn't for this case, every time you made a deal, you would have to worry, could the person come back and say, oh, I don't want to do that anymore. I want my land back. I want my car back. The other thing you need to be aware of, Fletcher versus Peck is the first time judicial review is used at a state level. Remember, that is why Jefferson supported it. This is a state law. This was a Georgia law. So why is that significant? Fletcher versus Peck is demonstrating that the Supreme Court can intervene in state matters, not just federal matters. Main issue, sanctity of a contract. I cannot tell you, it's one of those things that we all take for granted. When we make a deal, good or bad, you get stuck with it unless the two of you work out some sort of a compromise. Number 3, McCulloch versus Maryland. This one will come up quite a bit. This one is going to be in fact, this one will eventually be the essay on a later unit. McCulloch, it's what? M-small-c, big-C, U-L-L-O-C-H. McCulloch. M-small-c, big-C, U-L-L-O-C-H. McCulloch. Versus Maryland. 1819. Issue is the National Bank. In fact, if you want to be most honest and proper, it's actually the second national bank. The first national bank had actually expired in whatever it was, 1800. Must have been like 1806. So this is actually the second national bank. We won't go too technical. Folks, just like at the time of Jefferson, some states despised the national bank. There had always been that argument of necessary versus proper, should banks be a state issue. The state of Maryland was one of those southern state right states, and what they did is they began to impose a state tax against the national bank. And what is the problem? The Constitution says you cannot tax federal entities. You know, the U.S. cannot be taxed. The post office can't be taxed. However, the state of Maryland started taxing the bank. What is the state's argument? In reality, the state is arguing the national bank was illegal in the first place. The state of Maryland is arguing that the national bank really should just be a private commercial bank like any other bank. They should not get special treatment. It goes to the Supreme Court, and ladies and gentlemen, One of the things that I think often fools people is because of Marbury, because of Fletcher, we think that the Supreme Court is often coming in saying Congress is wrong, Congress is bad, Congress is dumb. In McCulloch versus Maryland, the United States Supreme Court rules, the Congress was right. The bank is legal. The state of Maryland is violating the law. In McCulloch versus Maryland, the United States Supreme Court, now that they have judicial review, remember under Washington did necessary and proper, there was no judicial review. In 1819, after all of these years, the United States Supreme Court is going to validate Alexander Hamilton and say the national bank is legal. No, because like I said, right now we're just doing the court case. And the last court case that we will deal with, there's a couple of other ones that might have some relevance, but again, this will get you all the main ones, or the rulings. It's called Gibbons versus Ogden,
How you spell that?
1824. Gibbons versus Ogden. Gibbons, and then Ogden is Ogden. Ladies and gentlemen, the issue is steamboats. 1824. Here's what happens. Folks, about this time, a gentleman by the name of Fitch first invented the steamboat. Originally, the steamboat was a very interesting device that made a lot of noise, and no one could figure it out. And what I want you to think about, folks, is steamboats have an inherent problem. They make a lot of noise, and two, the entire inside of the ship is filled up with what?
Steam.
Well, steam's kind of just gas. You need fuel, right? And you need the big engine. And as I say that, every year my kids look at me like, what's the problem with that? What is the problem of having the engine and the fuel?
It takes them over.
All of your cargo space. Ladies and gentlemen, what I want to point out is originally steamboats were novelties. And then it came to a man named Robert Fulton. Robert Fulton came up with the idea of taking steamboats and focus them where sailboats are weak, rivers. Rivers where you do not get a lot of wind, rivers that have a current that go against you. The steamboat could possibly have a purpose. The steamboat could be used to transport both people, like for example from, let's say, Albany, New York to New York, or, does everybody understand this? And please be aware, hint, 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 which we'll get to eventually. What makes this court case so dubiously important? Right about the same time, a gentleman by the name of DeWitt Clinton had just finished the massive, crazy, huge project of what is the largest internal improvement in the state of New York? Not the Hudson River, that's a river. The other thing.
Oh.
Canal.
What canal? Ladies and gentlemen, right about this time, hey, folks, this is something you guys do need to know. Because otherwise things don't make any sense. And when I say that, what is the don't make sense? Why is New York City twice, 3 times as big as any other city in America? Yeah, it's a beautiful harbor, but so is San Francisco. The reason,
It's a big trade area that people get to easily.
well, why is this one so much different? Who owns this? Spain or France soon. You're right. What we want to look at is this. We are going to build the Erie Canal to connect the East and the ocean to the Great Lakes. The Great Lakes are landlocked. By building the Erie Canal, all of the people who live in Wisconsin, Michigan, Ohio can now build products. They can put it on the Great Lakes, come up to the Erie Canal, send it down the Hudson River. So ladies and gentlemen, the Hudson River is not only a great ocean city, it becomes the gateway to the West. Most trade, most commerce, most business going out to here goes through New York, the Erie Canal. Now, this brings us back to Gibbons versus Ogden. Mr. Fulton had built a steamboat, and he began to transport goods from Albany, New York to New York City. Guess what's going to happen when the Erie Canal is finished? He's going to get a lot more business, right? Ladies and gentlemen, Mr. Fulton is going to sell his company to a gentleman named Ogden. And Mr. Ogden is a smart man. Mr. Ogden bought Mr. Fulton's contract. He then went to the state of New York and he worked out an exclusive steamboat license on the. Mr. Ogden had a piece of paper that said only boats may use the Hudson River. A monopoly. And as the Erie Canal finishes, Mr. Ogden begins to be filthy rich. He begins to start making money hand over fist. And that leads us to Gibbons. Ladies and gentlemen, Mr. Gibbons wants to get in on the steamboat trade. The problem is that exclusive contract. What Mr. Gibbons does is this. He sets up his company in New Jersey. He gets a federal trade license. If you look right here at the map, here's the Hudson. The Hudson River is 96% in New York, and 4% of it is in New Jersey. We'll finish that tomorrow. Please remember, you guys don't have class tomorrow. Tomorrow, my recommendation is make